advise that Fable? This is an appeal in the matter of sex at Charles.
Yes.
My lords, my lady, I, together with Mr. Slater, appear on behalf of the appellant father. Mr. Coercion of King's Counsel, Miss Chokri, appear on behalf of the respondent mother, and Mr. Rustin appears on behalf of the child through his guardian, Miss Demery. My lord, if I may begin with some housekeeping matters, we understand that this appeal is going to be live streamed today. So on that basis, we will endeavour to refer to the child by the initial A.
Yes, thank you.
And
the parents is mother and father?
Yes,
yes,
absolutely. And my lord, I'm not sure if any member of the press is here, but if that is so, we would ask for the usual order that the child is not identified.
Yes, yes.
In reporting.
Yes.
My lord, in respect of the timetable, we're aware that the court has to rise at 3:15 today. It's proposed that my submissions should conclude by noon, and then Mr. Coercion would endeavour to complete his submissions by 2:30 or thereabouts, followed by short submissions by Mr. Rustin and any reply by myself.
Right, thank you. See how we go. Thank you.
My lord is aware that this is an appeal against the findings of fact made by Mrs. Justice Theis in her judgment handed down on the 22nd of November 2024, and in particular the findings that are being appealed are at Schedule B of the order at page 27 of the core bundle at little Roman numeral 1, and they extend from A to K over the page. And the court will also be aware that Lady Justice King granted permission to appeal on grounds 1 and 2 in respect of the adequacy of reasons and whether the findings made at Schedule B, paragraph 1, are sustainable, and permission was refused in respect of ground 3. So the remit of this hearing is very much focused on those findings of fact. And my lords and my lady, I intend to structure my submissions, if I may, to first deal with the challenge that the learned judge failed to look at the overall landscape of the evidence and, in fact, assessed the evidence in silos without reference to the other relevant findings in this case, particularly around the removal of the child from Egypt. And secondly, I would intend to deal with the challenge on the adequacy of reasons when looking at whether those findings individually were rationally supportable. If I could start with setting out the key background facts that are relevant to the appeal. As the court is aware, A lived in Egypt throughout his life until the date of his wrongful removal in May 2022. All his family lived in Egypt, including both sides of the parents' families, save for one maternal aunt who lived in England. The findings made by Mrs. Justice Theis were that the mother applied for a passport for A and without the father's knowledge and consent, and further applied for a skilled worker visa and a visa for A on a fraudulent basis without the father's consent. And it was on a fraudulent basis because the mother produced and relied upon a forged custody order from the Cairo Appeal Court dated the 14th of October 2020, and the fundamental basis of the misrepresentations were that she had sole parental responsibility for A, and she also claimed she was divorced from the father.
And that was contrary to the mother's case?
Yes.
Right.
Yes. And, my lord, I will be taking the court to those references, but the mother throughout had maintained that the father not only knew of the proposed removal, but he in fact consented. And as was accepted by the court, the mother maintained an absurd and extraordinary lie in the witness box that she had not in fact read the custody order, even though she had produced it not only to the Secretary of State when making the visa applications, but also to the child school in this country in a bid to prevent the school sharing any information with the father about A. And it was put to the mother that it's likely that she also produced it to the border authorities in Egypt, because the evidence from the Secretary of State in the asylum application is that a parent could not remove a child from Egypt without the consent of the father. Furthermore, a fact that wasn't noted in the judgment was that the mother breached 2 successive court orders made by Mr. Justice Kean in October 2022 and again by Mr. Vernon of King's Counsel in January 2023, that she must produce a copy of this court order, and it was only produced some 6 months later. Furthermore, the circumstances of the removal are highly relevant because they demonstrate a premeditated and calculated plan with some level of deceit, we say, because notwithstanding the fact that the mother knew that the visa applications were granted on the 8th of April 2022, during the weeks thereafter, she duped the father into believing that a school place in Cairo was being applied for and obtained for A to start that September. Furthermore, the mother accepted, and this again is recorded in the judgment, that the mother worked in the same company as the father in Cairo. She was obliged to give 1 month's notice to her employers, but to avoid the father becoming aware of her plan to leave Egypt, she asked her father, the maternal grandfather, to tender her resignation after the date of removal.
I thought that was also referred to in the judgment.
Yes, it is,
Yes.
my lord. And these are all agreed facts which should not be a matter of dispute because they are in the judgment. Furthermore, the mother accepted and that when she left the family home to live with the maternal grandparents in November 2021, that home was a 5 to 10 minute walk away from the family home where the father remained. And furthermore, the judge records in her judgment that there were no incidents of concern and the mother and Jason were able to live in safety. The learned judge further accepted that the mother had actively pursued a reconciliation with the father during those 6 months, and in fact blamed the father for not responding to those overtures. The judge accepted that the father continued to have limited contact with A. In fact, in evidence, the mother said it was once or twice a month that father was seeing A at the nursery. The father said it was weekly. The facts thereafter, in brief summary, are that having arrived in this jurisdiction and lived with a maternal aunt in Brighton, the mother and A were forced to leave Brighton and have effectively been living in destitution since the end of 2023, because she not only lost a job at her brother-in-law's company, but the premise of her skilled worker visa, which was attached to that specific job, was vitiated. And this led to the mother writing an email to the father's solicitors on the 9th of January, first indicating that she was intending to voluntarily return to Egypt with A, but then changed her mind and claimed asylum one day prior to a listed final hearing before Mr. Verdun of King's Counsel, which led to that hearing being abortive. The father has been having weekly video call contact with A since that was ordered by Mr. Justice MacDonald in July 2023. The father has attempted to apply for a visa to come to this jurisdiction, but that was refused. The mother has maintained she has no intentions of taking A back to Egypt at any point. So the prospects of A seeing his father again are negligible on the current facts.
Well, when you say that, it depends on the outcome of the substantive application.
Absolutely.
It might be thought the sooner that is determined, the better.
Yes, my lord.
But in bringing this appeal, it might suggest that you think these findings are somehow, have some significance in the context of determining the return application. It might be thought that there are other more important factors which would weigh in the court's mind when deciding whether or not to order the child's return to Egypt. But
my lord, it might be summarised by the fact that within the Guardian's report, I can take the court to that now, it's in supplementary bundle at D56. The Guardian...
What page, sorry?
It is D56.
D56, sorry.
Yes, in supplementary bundle.
Thank you.
If I find the exact quote.
yes,
The Guardian said if the court makes no serious findings against the father and the mother was found to have created an untrue narrative, then this would indicate that A should be returned to Egypt, particularly in view of the instability in his living arrangements in the United Kingdom.
yes.
And that is a proposition that the father's team very much supports.
Yes.
Can I have a moan about the supplemental bundle, please?
Yes.
It's very nicely prepared in A, B, C and D with individual numbering within each of those categories, but it doesn't work electronically because I need the electronic number. I'm using it electronically, so if you could give me that as well, that would be very much appreciated.
379,
Got it.
my lady.
Got it.
Thank you. The other brief points that I simply...
Well, as found by the judge, the mother had created a significantly untrue narrative.
Yes. Save for every part of the mother's case was essentially rejected, save for those findings in respect of physical and emotional abuse.
Well, 3 and 4 of the schedule, save for 2 parts of it. 3A wasn't accepted in full, and 3E wasn't accepted in full. Yes.
Yes, the references to the father having abused A,
Yes.
in particular shaking him and hitting him,
Yes.
were rejected by the
Yes.
court.
Yes.
So, my lords and my ladies, if I can now turn to how those findings at paragraph 1 can stand when one analyses the remainder of the findings that were made, and this was a point picked up by Lady Justice King in the grant of permission.
Sorry, can you say that again? How the findings can stand when
one analyses the overall landscape of the evidence and the other findings that were made in respect of the mother's credibility, and those specifically that are set out in the order from paragraph 2 onwards.
This is really at ground 2, is it?
At page 28.
Yeah, but you're taking your ground 2 before
Yes,
your ground
yes, yes. And as I've already highlighted, the central legal principle that we rely upon here is that a judge cannot compartmentalise the evidence and must evaluate each piece of the evidence in the context of the totality of the evidence. The main analysis of Mrs. Justice Theis is set out in her judgment at paragraph.
Sorry, I'm just trying to puzzle over the submission you made, how the findings can stand when one analyses the overall landscape of the evidence and the other findings made about the mother's credibility. I mean, the fact that I don't see any correlation between a judge finding a party unreliable or lacking credibility in respect of some allegations, but nevertheless deciding that they are credible in respect of other allegations. That's not a principle of law. And one analyses the overall landscape of the evidence. The overall landscape of the evidence being what?
Well, I was going to break this down.
Okay, could you? Because I don't, at the moment, I'm not speaking for myself, I'm not entirely
into
following.
the separate categories, because when one looks at the main analysis of Mrs. Justice Theis, paragraph 75 onwards, there is no reference at all to the father's case that the court had to scrutinise the mother's overall motivation in coming to this jurisdiction, the manner and timing in which the domestic abuse allegations had been raised, and the scale of the inconsistencies within her account. So if I can start with the findings in respect of the wrongful removal and the scale of the mother's deception in respect of that, I can ask the court to look at the fake custody order that was produced by the mother, and in the supplementary bundle it's E1. I'll just try to find the PDF number.
The Egyptian custody order is 397.
397, thank you. One, first,
Sorry, what was the paper?
it's E1 in the supplementary.
B1.
E1.
E1, thank you.
The cover page is significant because it is the declaration of the interpreter. The translation was obtained, of course, on the 4th of March, and it was an interpreter based in East Sussex. And the order starts at E2 on the subsequent page, purports to be from the Cairo Appeal Court, and goes into some considerable detail on E3. The appeal rested upon the premise that the mother said that the father knew nothing about the child since he was born. That is the 4th paragraph on E3. And that the assertion within this order, which the authorities would have read, was that the father had managed to obtain custody of the child through manipulation, tricks, and misinformation. And it goes on to say at E4, it makes an assertion in the 2nd paragraph that the mother had submitted a divorce document from the father due to his bad behaviour, obviously attempting to malign the father in the eyes of the reader. There were names for 2 witnesses given this document, which the mother said she'd never heard of. And furthermore, at E5, in the 3rd paragraph, the substance of the order purports to show that the appeal court took the view that the father had hidden evidence in court for the purpose of misleading the court. The mother's explanation in her written statement for this and in the oral evidence was simply, I never read it, I take no responsibility for it, and if the court has had the opportunity of seeing her oral evidence and the cross-examination from 151 onwards, I can summarise it. She went from blaming an Egyptian lawyer to saying that she in fact did not know it was a custody order, without being able to explain why she would have supplied a copy of this custody order to all these agencies, to then contradicting herself, saying it wasn't an Egyptian lawyer, it was a travel agent who had given it to her. And she then gave a very confused answer, 156, as to whether it was herself or the travel agent or the brother-in-law who had commissioned the translation. And this does need to be assessed in alongside the evidence that the mother's case, that the father had consented to this removal and had known at all material points of the chronology of the plan for his son to move across the world to the United Kingdom. And the judge at paragraphs 49 and 50 of her judgment rejected that case entirely and said the evidence points all the other way. So the question we say should have been asked by the learned judge and scrutinised is, why did the mother tell these absurd lies on this magnitude in the face of overwhelming evidence? And there were 2 different answers, which are diametrically opposite, that were given. The mother's attempt to of an explanation was to say she was in desperate fear of her life and of A's life, that the father was effectively persecuting them and they had to flee Egypt for their safety. Of course, that case was ultimately not accepted by Mrs. Justice Theis, because she found that they were living in safety at the grandparents' home. And there was also reference in the mother's initial screening interview to her saying to the Secretary of State, I came to this country to work. She was asked a specific reason, was there any other reason you came to this country? She said no. And she went on to say that the moment when she realised she could not return to Egypt was May 2023, after the father had issued an application for the return of A to Egypt. The second explanation for the mother's lies, which we say is the correct one, is the mother has engaged in subterfuge on a grand scale. She had made the decision to move to this country essentially as an economic migrant. She knew the father would not agree. She knew that she required his consent. And the only way to bypass the father was to obtain a forged court order. And that was the cornerstone of the father's case, which was clearly set out in the closing submissions and just simply was not addressed by the judge at all.
So the judge found that the document was false, found that the mother had that her explanation for leaving Egypt were not true. So effectively, did not judge find that the mother had engaged in subterfuge, just to adopt your wording, on a grand scale? Didn't she make findings that effectively amount to that? Why does the judge have to go on and say, so I find that she engaged in subterfuge on a grand scale, rather than looking at the underlying facts?
I accept that, my lord. That's not the source of the challenge.
Right.
The source of the challenge is that the analysis stopped there and did not go on to examine how that affected the credibility of the mother's allegation case that she was fleeing Egypt as a victim of domestic abuse. Particularly where the mother's evidence was riddled with inconsistencies and discrepancies and was not internally consistent.
So your submission really is that the weight of the evidence was such that there was no option open to the judge other than to reject all of the mother's allegations as set out in the schedule. Is that it?
I wouldn't go that far, my lord. I would say that is one aspect of the case, and I'm going to go on to address the other areas where the findings made by the judge in totality should have led the court to reject the credibility of the mother's abuse allegations. And of course, the judge was obliged to scrutinise the detail of those allegations, and that is the second limb of our appeal, that when one looks at the evidential basis for those findings, that was flawed. In looking at the mother's case, and I just to give the court the page references as to how the mother was articulating her case. I've already said that the mother had asserted that she'd gone so far to say that both her and A's lives were in danger. And in the supplementary bundle, that's C17, paragraph 55. That's PDF 99. And in the asylum interview at E21.
Sorry, what are we looking at? You said C17. What's that for?
C17, paragraph 55.
Yes.
This is how the mother pitched her case. She said that A and she would face serious abuse.
Yes.
If they return, that the father would take revenge on both of us.
Yes.
And our lives would be in danger.
Yes.
And then in the asylum interview record, PDF 416, paper bundle page E21. The mother...
E21.
Yes, at the top of the page.
Thank you.
The mother said that the father might kill me. He might take my son away from me forcibly. The court was also referred to the timing of the mother's referrals to outside agencies in this jurisdiction, which all followed the issue of the summary return application. And there were three pieces of evidence which all closely align. And again, they're in the supplementary bundle. If I take them in page order, first one is at C 190. (272) electronic page, and the entries are at the bottom of the page. 1st of February 2024. So shortly after the asylum claim, the mother was reporting that she was separated from her ex-husband, who was trying to take her son away from him. And the fallacy of that assertion is that the father has never suggested that A lives with him. He's never made an application to custody in Egypt. He's never suggested in these proceedings, in this jurisdiction, that A should be removed from his mother's care.
Sorry, can you just point, where is that on that page?
It's the bottom entry, 1st of February 24, 16.
Oh, I see, thank you. I thought, does the judge not refer to this in her judgment?
No.
Or is it referred to in the skeletons?
Yes, he's correct.
Yeah, okay.
The second entry is a few pages on C203. The mother submitted all this evidence. This is 285. This is from a mental health practitioner in a letter, again, dated January 2024, around this time. And what it says in the third paragraph is that the mother advises me that she came to the UK on a work visa originally, but after a period of time was unable to continue work due to the abuse she continued to experience from her husband. On any view, the mother's case was that the last incident of abuse had taken place on the 24th, 25th of November 2021. There is not a shred of evidence that there were any further incidents in Egypt or in this jurisdiction. And the final piece of evidence was cited in The Guardian in her report at D43. .366 in the bottom box. The mother self-referred to Children's Services, and she claimed that she was a victim of physical, financial, sexual, emotional and verbal abuse. She said A witnessed the abuse and father was also physically and emotionally abusive to A. Of course, those allegations were rejected by the court. And she went on to say, as she had to other professionals, that A did not like speaking to his father and got distressed during those video calls, which of course, which was conflicted with her evidence in the witness box, which is that this contact was beneficial to the father. And we say all those strands of evidence painted a picture of how the mother untruthfully depicted herself as a victim of ongoing and persistent abuse from the father, to distort the reality. And she was doing this as a means to an end, to gain support from professionals, to make a claim for asylum, to defeat the father's application of a return order. And to have pitched her case at such a high level of a fear of death, of course, is entirely irreconcilable with the mother's evidence to Mrs. Justice Theis that she wanted to reconcile with the father and that she actively pursued reconciliation after leaving with the family home. And it also is inconsistent with a complaint made by the mother that the Egyptian authorities did nothing after November 2021 in that they did not bring criminal proceedings. And the court does not necessarily need to turn it up, but it's at C177, the supplementary bundle. If the mother, again, the point is obvious, if the mother was pursuing a reconciliation and wanted the parents to, again, provide a joint family home for A, why would she have been pursuing a criminal prosecution? And why is she making that complaint unless she wanted to persuade the court and others that she had not been adequately protected in Egypt?
And none of that was accepted by the judge?
Yes, my lord. There are three other fundamental findings that we say undermined the mother's case of physical and emotional abuse. If I can turn...
Sorry, you say three other findings.
Yes.
Why do you say these findings undermine the judge's finding? Are you saying cumulatively?
Yes.
Okay. So right. Yes, three other findings.
Secondly, we know that the court rejected the mother's account that she was a victim of persistent and serious sexual abuse, which was happening, she said, twice to 3 times a month. And the mother's case is encapsulated in the closing submissions that were filed by her legal team, and in the core bundle, they're at page 306.
Sorry, do we need to look at those when we have the allegation or something that is set out in the schedule?
Well, I just wanted to highlight how serious these allegations were.
Can you give me the page again, please?
It's 306.
Of the...
core bundle.
Thank you.
It's paragraphs 86 and 87 in that document. The case put on behalf of the mother in summary was that she was forced into another room to have intercourse, and during...
Well, I think we know, I mean, we can read them, but we know what's set out in that. You don't need to... And that was rejected by the judge.
Yes, but I would ask you just to read paragraph 87, because that highlights the summary. And if I can take the court now to the judgment as to the reasons why that case was rejected by the court, it's at paragraph 80 on page 19 of the core bundle. And it starts at approximately 6 or 7 lines down on page 19. I'm not satisfied to the required standard.
Yes.
And the reasons given were the lack of consistency in the mother's account, the delay in the allegations being raised for the first time in August 2023, and in response to the father's application, which she vehemently opposed.
So that's accepting your case?
Yes, but this is equally applicable to the allegations of emotional...
The judge found that it wasn't equally applicable.
Well, my lord, my argument is that this was not factored in to the evaluation when the judge analyses the allegations of emotional
I'm sorry, I don't understand. How can it not be factored in when it's referred to in the same paragraph?
Well, we don't see any analysis as to why the sexual abuse allegations were rejected, but the emotional and physical abuse allegations could be
Isn't that
accepted.
the job of a judge to pick their way through? I mean, sometimes you do get mixed findings. Was it irrational or not open to the judge to say, well, I do accept some of the allegations of verbal and physical abuse, but I'm not going to accept the much more serious allegations of sexual abuse? That was certainly open to her, wasn't it?
Yes, it is. The appeal does not rest on this ground solely, but as I've already indicated, these are cumulative arguments as to.
They don't get better. I mean, if the basic proposition isn't a good proposition, it doesn't get better by aggregating it with other things, does it?
Well, when looking at the sexual abuse allegations, again, the judge looks at the fact that the mother was open to reconciliation. And that's a factor that I've just referred to in looking at the overarching motivation of the mother. So what this analysis demonstrates in paragraph 80 is that the judge was satisfied that those were valid points to undermine the credibility of the sexual abuse allegations, but no reasons are offered as to why those same factors did not undermine the allegations of emotional and physical abuse.
Well, except that she simply rejected your client's account for reasons that she does explain on the October and November issues. I mean, you may say she had to choose one or the other, didn't she, on those allegations, and she didn't like what your client said.
I will be addressing the detail of those reasons. The third findings were the court rejected.
Sorry, wait a minute. You said three other findings. One I've written down as rejected the mother's account that she was a victim of persistent and serious sexual abuse.
Yes.
So we're now on to
Third. So I had the findings with respect to the wrongful removal and the circumstances of the removal were the first one, and the mother's overarching motivation. The second finding were the sexual abuse findings.
So the first one was the mother engaged in subterfuge on a grand scale. Sorry, I'm losing. What was the first one?
It were the findings of wrongful removal.
Right. Okay.
And the subterfuge that the mother engaged in.
Is that saying that she was in fear of death when that
yes,
was rejected?
And her overarching motivation
that's issue 1.
In coming to this country.
Right. Okay, so that's one. Two is rejected the mother's account of persistence. Yes, and three is
rejecting the mother's case that she was a victim of coercive control. And this did feed into some of the findings made by the court. This is addressed in the judgment at paragraph 82. And on page 19, the judge was not satisfied that there was credible evidence that the mother was unable to seek the assistance of her parents when she needed it. She went there in October and November, and it's that aspect that did feed in to the accounts given by the parties of why the arguments were taking place in November 2021. Because, for example, when one looks at finding J, the court accepted the mother's account and narrative that the father did not allow the mother's parents to attend the operation. Well, of course, factually that's incorrect because they did. That was accepted by the mother. and the mother's case was that she had been threatened that he would show her what he was going to do and was attempting to control her, in particular in respect of her parents. And the finding is that the father was attempting to prevent her having any relationship with her family. But in a general basis, the court was not satisfied that the mother was in fact prevented from having that relationship. And the final finding that I want to refer the court to was the rejection of the mother's case that the father had abused A by shaking him and hitting him. This was, the ramifications of this were wide because A himself had reported to the guardian these allegations of abuse, and they're in the supplementary bundle at D49 and D53. So, paragraph 30 on D49.
Yes.
372.
I'm so sorry, I'll have to help me a bit more. Let's say again, 30.
372.
372.
This was the second report because there was a change in family court advisors. And A told the guardian, his guardian, that his father used to hit him and his mother, and he did not know why his father hit him or where he hit his mother. And he then said his father hit him everywhere. He did not.
Yes, okay, well, we've read that.
And
I think it helps reading it out.
the analysis of the guardian is at paragraph 52, at D53. And the guardian's analysis was that she was concerned that no detail had been provided.
Yes.
And at paragraph 54, the guardian expressed her opinion that A has not expressed his authentic wishes and may have been subject to undue influence by the
Yes.
mother.
Yes.
The reasons why the judge rejected those clearly very serious category of allegations of paragraph 81 of the judgment.
Yes.
And nowhere in the analysis is there consideration of why the mother would have made false allegations that A had been abused in the context of the guardian's views that he had been unduly influenced to repeat allegations which were not coherent and lacked the detail.
So no consideration of why the child made false
Yes.
allegations.
Yes, repeated those allegations. Under the spectre of undue influence. Again, this goes back to what the mother's motivation was in painting the picture that she was the victim of abuse.
I don't think it's very hard to understand motivation. It's creating a false case for a purpose, to try and improve her position in respect of the application made by the father for the return of the child to Egypt. Does the judge have to spell that out in her judgment?
My lord, I would suggest
The judge has rejected numerous of the mother's allegations, including the most serious ones.
Yes, my lord, in those unusual circumstances where it was accepted that the mother engaged in such an extreme deception, there was a need for very careful scrutiny of the allegations of emotional and physical abuse. And my Lord, I am now going to move on to analysis of those findings in respect of, and also in the context of the challenge in respect of adequacy of reasons.
Right, thank you.
And of course, the court knows the fundamental principles. Our essential challenge here is that perfunctory reasons were granted as to why those allegations were accepted. The core case of the father was not regarded, and we say that there are too many pieces of the jigsaw missing. And in the task of the appellate court in reviewing the judgment, which we accept is in the context of material evidence submissions at trial and not simply what is written down in the judgment, we do submit that it is not apparent why the judge reached the decision that she did. And of course, the ramifications of these findings are hugely significant, as they will be lifelong, not only for A, but also for the father, and will determine the role that the father can play in A's life. They will also guide professional assessments and ultimately, as has been said in all the authorities, adequate reasons have to be given so the appellate court can review the merits of the decision. If I can start with a brief point in respect of how the mother's evidence evolved, the court is aware that having signed a lengthy statement on the 29th of August 2023, the mother then attempted to resile from aspects of that statement, and an amended statement was filed in April 2024. And as we'll see, that caused some evidential discrepancies in this case. And there was much confusion, in fact, that is illustrated in the findings. On at least one occasion, the mother's retraction and amendment was not in fact accepted by the judge and was still finds its way into a finding. Overall, we know the judge was fully satisfied with the mother's explanation that she did not have an interpreter, which would be surprising given that they were panel solicitors. And the court had been addressed by on the fact that the mother accepted in cross-examination that she reads English and that she had told the Secretary of State that her preferred language to communicate in is English. And of course, the objective facts are that the mother obtained a skilled worker visa as a customer service manager working with a company called Entrepreneurs Business Solutions, where she was supporting Arabic-speaking clients, which would, of course, in itself indicate a proficiency in English. But looking at the core findings made in 2021, in October, I can start with October 2021, and that's the finding at C. If I can just summarise the discrepancies which in the mother's fundamental accounts. In the schedule, it was A17, the complaint was that the mother was spat at. on that day by the father. That was the finding sought. And that was conflicted entirely with what was contained in the mother's statement. And I will ask the court to look at that. It's in the supplementary bundle at C11, paragraph 29. 93.
93, did you say?
Yes, so if I could ask the court to read that.
Sorry, paragraph 29.
Yes. So it's essentially a completely different account. And for the sake of completeness, I'll take the court to the amended statement. Paragraph 29 was not corrected, per se.
Sorry, what's the page reference?
C174, which is PDF 256. But the mother did say this.
Sorry, which?
C174.
So it's paragraph.
Paragraph 29 in statement.
Oh, I
1
see.
not-
Is absent.
It's not correct.
I've got it.
But
Yeah,
the mother
okay.
did say this on this page at paragraph 26. She said the father would shout and shake the child, but did not kick him. So that shows that the mother had gone through this initial statement carefully, but at no point sought to correct her version of events of October 2021, save for that. In the asylum interview, I'll just provide the court with a reference. It's at E23. Again, the allegation, the fundamental allegation, what happened that day was spitting. And finally, if I can just take the court to the transcript of the mother's oral evidence in the core bundle, and that's at 186.
Sorry, before you do that, what was the reference again for the asylum interview?
It's E23,
Thank you.
418 PDF. And I'll refer the court to the mother's evidence at the top of the page. Section A.
So this is referring to October 21.
Yes,
Sorry, is this cross-examination or?
cross-examination, yes.
Thank you.
The entry starts at 185G. And I'd ask the court to read up to section C, 186.
Yes.
So we can see that the mother started to say one thing, that she was slapped, and she corrected herself and said that it was in fact the assault was being spat at. And that was the assault which she claimed constituted a criminal offence. And the judge did not analyse any of that evidence, any of those discrepancies. and simply adopted what was in the schedule at finding C. The next illustration as to how the granular detail of the mother's evidence was incompatible with the finding that was made is in respect to the most serious finding in November 2021. First of all, an aside, there was a factual dispute between the parties whether A had actually been present in the car during the first part of the incident. The judge did not resolve that. The father said he wasn't there. The mother claimed he did. If I can try to summarise the points, but I'll give the page references. In the first part of the assault, said to have taken place in the car, the mother's evidence ranged from saying she was assaulted with a punch with the father's fist.
Sorry, where are you?
That's in the schedule.
So it's the schedule 3D. Yes?
Well, those are the findings, but the Scott schedule was at A17.
So I didn't mean that. I meant 3D in the schedule. Paragraph 3.
Yeah, schedule B, yes.
D. Yeah?
Yes.
No, not schedule. I've got it at A11. Might have the wrong reference. But in other words, the schedule that's produced for the purposes of the hearing. Is it A11 in the supplementary bundle? It may be. And it's 3D in that schedule.
Oh, yes.
That's what I was referring to.
Yes, my lord.
Thank you.
So I think that is replicated in the order.
Right.
In
So
schedule B.
that's the summary of the allegation that's set out in the schedule.
Yes.
Yes.
And in the statement at C11, what the mother actually described.
Hold on.
Paragraph 31. '93. It's the third line from the bottom. Is she described a slap? So there's either punch with a fist, a slap. In the asylum interview, she said she was slapped and hit on the back, and the page references E26.
Sorry, say it again. In E26
Is the asylum interview.
Yes. Do you want us to look at that then?
It's a matter for your lordship, your ladyship.
What paragraph of the asylum interview? Page?
421.
And whereabouts on that page?
It is the fourth line down. He hit me and slapped me and hit me in the back. So it's not only how the mother was assaulted, but where it was on her body that differed. And in the witness box, it's at 187 for the call bundle. At section.
Sorry, say it again. 187.
187 D in section D and E. You'll see that the mother's assertion there was that it was a punch with a closed fist to the shoulder. The discrepancies.
Sorry, wait a minute. Oh, I kind of see. Sorry, yes.
Discrepancies in respect of the finding at E as to what happened later that day are more fundamental. In the Scott schedule, no findings in fact sought at all about what the mother claimed to have happened later that evening at home. And this is where the confusion in the mother's evidence in the context of her seeking to amend her original statement is particularly prevalent. We'll take the court to her initial statement at C12, paragraph 35.
Can you just what's the finding to which this submission is directed?
E. On page 27. PDF 94 in the supplementary bundle.
C12.
Paragraph 35, if I can invite you to read the first two sentences. So that aligns with the finding at E. But the mother sought to resile from this in her amended statement at C175. So C174. PDF 256 at the bottom paragraph of that page, where the mother emphatically says that she was not dragged by the hair. And she went on to say over the page that she was hit with a fist on her back and also slapped on the shoulders with open hands. And we say what becomes clear is by the time that the mother had filed this statement in April 2024, she was aware of all the inconsistencies and she was trying to cover all the ground. In the asylum interview, again at E26, the mother gives a very different account.
D26.
E26.
E26, sorry, yes.
421. The allegation was that all lines down, the father hit me and slapped me and hit me in the back.
Oh, okay, so you referred to that about the incident in the car. That's not. This is.
Oh, yes.
So, what is there another reference about the incident in the car or not? So we should.
No, I think this.
This is the car.
Yeah,
this is in the street in front of everyone.
It's when they went home. When we went home. So that was my mistake earlier. Yes. when we went home, he hit me, so he hit me in the back. So that does correlate to finding E. The reference to the car incident is at E25. It's under box 46. The allegation there was that she was hit on the shoulder when she was driving. And that is about 7 lines from the bottom.
So I'm going to change the reference to E26 in respect to the car to E25. And where is it again?
It is box 46.
He opened the door really hard, broke the door. That one. Is that it?
Yes, he says he was hitting the car inside and hitting shoulder whilst I was driving. About 7 lines from the bottom, 46.
Oh, okay. Thank you.
And what the mother said in the witness box is fairly critical, and that's at page 188 in the core bundle, and this is again under cross-examination.
Hold on.
Core bundle, which page?
188. And the relevant section is at B to E, 188.
B to E.
Yes.
Thank you. So just to summarise, that C12 shouted, in the first statement, shouted at me and dragged hair. The amended statement, not dragged by hair, but slapped and hit me.
Yeah.
Slapped shoulders with an open hand. The E26 slapped me and hit me in the back, and this is closed fist on the back.
Yes, and emphatic denial that she had not been dragged and pulled by the hair at section E.
So then if you look at the finding in B in paragraph E,
Yes.
your submission, as I understand it, is that there was no evidence of dragging by hair.
Well, it's a paradigm example of the fundamental inconsistencies in the mother's account. But actually the evidence that the court had heard in the witness box was that the mother denied that she was dragged by the hair.
No, but the mother had already withdrawn that.
Yes.
So there was no evidence, you say, of that element of the allegation.
Yes.
And
the mother had said at C174 that she had had marks on her face as a result of this assault, and obviously there was no evidence provided of that, even though she said she went to see her parents and went to stay with them, and she claims to
that's a slightly different point. But so that is, and slapping face and hitting her, that the mother's oral evidence doesn't refer to slapping face, but am I right that the statement does?
Well, there's a discrepancy again, which area of the body, whether it's shoulders, back, face.
you.
Those are, we would say, fairly significant inconsistencies in the mother's account, which simply were not addressed or evaluated within the judgment. The mother had sought to rely on corroborative evidence in respect of that incident by providing evidence in what was referred to as a restraining order or in an undertaking from visiting the police station on the 25th of November. This was referred to in the background, but the evidential weight of this evidence was not factored into the judge's evaluation. The police report can be found at C23 in the supplementary bundle.
Sorry, can you tell me again, what's the submission in respect to this?
This was evidence the mother sought to rely upon as independent corroborative evidence of the incident in November. The judge referred to the fact that the mother said she had made a police report in the background summary, but she did not weigh it into her evaluation of the competing cases of the parties when making her findings.
Could I have the page for the police report, please?
105. The key issues that are relevant from looking at this document are that the mother said that she'd been the victim of repeated assaults, but the address that she gave was not the family home address. It was the address of her parents. And furthermore, when the question was asked, is there any eyewitness, the mother had said all of the residents and neighbours. And of course, no witness evidence was adduced in this case. The father had addressed this in his own statements. I could summarise it for the court's references, C121 and C122 of the supplementary bundle. He makes the obvious point, there's a clear contradiction here. The mother says she went to the police. Why did she give the wrong address? And then complains that they never took sufficient action. But he also makes the point, I was never spoken to by the police, and I therefore doubt that this report actually took place. In a case where such significant adverse credibility findings have been made against the mother, we would say that this was an important piece of evidence that should have been weighed up in the judge's evaluation. If I can move to look at the substance of why the court was dissatisfied with the father's explanation and his evidence. It was said at paragraph 77, the judge agreed with the observations of the counsel for the guardian, Mr. Powell, that the father had been evasive. But when one actually looks at the detail of Mr. Powell's closing submissions at page 312 of the court bundle, this was not in the context of the abuse allegations. And the points relied upon that were adopted by the judge against the father was that he was somehow evasive about the mistakes he made and was unable to provide sufficient details of marital arguments. That's at paragraph 69 and 79 the judgment. Brief points I'd seek to make are, of course, we would say that in of itself does not reverse the burden of proof. The judge needed to rely upon evidence rather than speculation. The father had not been avoidant in explaining why marital arguments had taken place, and an example is what the Guardian reported in her report at D49 in the supplementary bundle at paragraph 35, because the father was able to have a discussion with the Guardian about this. And it's at the bottom of D49.
You need to give the PDF again.
372. I just refer the court to what was said there.
After the hearing and after the judgment was received, was there any attempt to engage with the judge in respect of matters that you say were matters in which, respect to which you say there was no evidence to support an element within the findings, such as dragging by her hair?
No, that specific issue was not put to the judge in the request for clarification.
Do you remember what was put to the judge in the request for clarification?
That is at the end of the core bundle at pages 323 and 324. Primarily the findings set out at Roman numeral 2 onwards were sought.
Sorry, hold on. 323. So it was seeking additional. Yes, I see. So it wasn't questioning findings that the judge had made or asking for further reasons to support those findings. It was asking for a separate raft of findings on behalf of the father.
Yes.
Was there a reason why you didn't ask for reasons, given that your ground one is a reasons challenge?
We would say that this is a case that fits into the category where the scale of deficiencies were too large to make all of these points in the form of a request of clarification. And it wasn't, I think the phrase has been used, is it a quest to seek additions or foundations? And we would submit that this challenge falls into that category and would have essentially perhaps been criticised as an attempt to re-argue the case, because all of the matters, I think nearly all of the matters certainly, were all addressed in written closing submissions. The final aspect of the reasons given by the judge in respect of doubting the father's version of events was a point again picked up by the mother's team as to it was asserted that the father had been avoidant or lacking candour in explaining the circumstances in which the mother and A had left the family home in November 2021. And it was said that there was differences in whether he had characterised this as a separation and whether the parties had, in fact, finally separated. The simple point I wanted to make in respect of that is that even from the mother's perspective, this was a fairly fluid situation in that she had said that she was actively pursuing a reconciliation. There was these parties were meeting every day at work, obviously having contact there. That's evident from the messages that were being exchanged. And the father was having contact with A. So the boundaries were blurred, we would say. And if I can just give the court some evidential references in respect of, within the transcript of evidence, in the core bundle, it's 162, 164, 168. The mother repeatedly said that she was actively pursuing a reconciliation. The judge accepted that the mother's fairly exorbitant claim that she was in fear of returning to the family home to collect her belongings was not credible. And the court was able to see the evidence of the messages being exchanged between the parties at that time. There's 2 pages of messages at C239 and 240, which are from February 2022, which show perfectly cordial, amicable exchanges. And they also show that the grandmother had her operation in February 2022. That was material because the judge relied upon an assertion made in the closing submissions for the mother that the grandmother's illness had nothing to do with the mother going to stay with her parents. But it's clear from these messages that, in fact, the grandmother was having an operation by February 2022, and there was actually, in fact, no direct evidence before the court as to when the diagnosis took place. In fact, there were also messages that were seen by the court from April, May, June, July 2022, when, including the period when the father became aware that his child had been removed to another country. And even in those strained circumstances, the father continued to be entirely cordial and amicable in his tone with the mother, and the mother was not able to adduce one single abusive message that she says was sent by the father towards her. And that, of course, is highly relevant in a case where findings of emotional abuse were made. My lord, and finally, I just wanted to make some additional points on each of the other remaining findings at Schedule B. If I can start with paragraph A.
Yes.
As Lord Justice Moylan has already indicated, the judge did make one amendment here because there was a conflict between what the schedule said, which was that the mother was hit in the belly, and with what was actually contained within her statement. The judge says that she was simply says she's accepting one version over another, but doesn't give any reasons or analysis why. And the mother was unable to clarify this in the witness box. In respect of B, that again there was a direct conflict in the mother's evidence as to whether the father fractured his fingers as a result of attempting to take a swing at the mother effectively and missing her and landing on the door, or a completely different account as to whether he was knocking on the door so loudly in anger that he fractured his fingers. And the divergent accounts are given at C9 paragraph 23, and E24 of the asylum interview.
Sorry, so C9 paragraph 23 says what?
It's the statement that the mother says that the father essentially missed her and hit the door. And in the asylum interview at E24, she said he fractured his fingers because he was knocking on the door with excessive force. They're fundamentally different.
And in oral evidence?
My Lord, I just need to find that passage in the oral evidence.
Right, okay.
My Lord, I may have to come back
Right,
to that,
okay.
if I may. The father's account was not factored into this at all. He gave a perfectly innocent explanation as to how that injury was caused. That's page 225 of the transcript, section C. He said that he was trying to fix a door or he was trying to shut the door properly on a windy day, and the door essentially shut on his fingers. He also referred to the fact that there was a photo of this injury, and that's in the bundle at C249 when the parties and the child were seen in a perfectly happily together.
Supplementary bundle?
Yes.
C249.
Yeah. And he referred to this in his re-examination of his evidence.
Sorry, I don't have a C249.
It must have been omitted in the supplementary bundle.
Right.
The reference to the photograph is at C237 in re-examination of the transcript. Brief point, which I may not have said earlier, in respect to the October 2021 incident at paragraph C. Of course, one of the most significant parts of the mother's account was that she alleged the father hit and kicked A on that day. That there is no evaluation as to why that central aspect of the account is rejected, but the rest of the finding is accepted. It is incorporated into a finding. In respect of F,
so nothing on D.
I've already dealt with D and E. It's the 24th.
Oh, sorry. Yes, of course you have. Yes. Thank you.
In respect of F, that's dealt with page 303. I think that's...
Sorry, 303.
303. These are the closing submissions on behalf of the mother.
This is... Can you remind me which bundle?
The core bundle.
Thank you.
So this is how the mother's case was put in closing at the trial in respect of October 2021. was positively asserted,
So which paragraph?
74, that during that incident, the father held Jason by his held A by his shoulders and shaken him and tapped his hands and shouted at him. And it is as a result of that that A asked whether the father would kill them. So the two were connected. There was a nexus. And at F, we see the judge rejects half of the nexus but accepts the other. At paragraph, the finding at G, I've already made the point that there was no evidence of abusive messages or any of this emotional abuse. And in fact, the concession was made in that same page of the closing submissions at 303, at paragraph 77, that the allegations of emotional abuse were not significantly canvassed in the oral evidence. Therefore, the judge heard no real evidence from the parties in respect of G, H, G and H in particular. Moving over the page to I, there's again a mismatch with the evidence because this part of the schedule was just accepted in its entirety. But where one finds it in the evidence is in the mother's statement at C10 in the supplementary bundle, paragraph 26. PDF 92. And again, the point is this.
Sorry, wait a minute, hold on.
C10, paragraph 26. Perhaps I should let the court read that. So the point is that the most serious allegation here is that the father regularly kicked and slapped A, and that the mother had to stop him from doing so. That is rejected by the court, but the rest of this narrative is accepted as true. And furthermore, at C174 in the amended statement, the mother corrects paragraph 24, and she says that there was only one occasion when the father picked up the phone call and said that George left him alone. And 256, and she goes on to say that it wasn't correct that A would sleep all day. He would in fact be on the phone while his father was sleeping until noon. But essentially, this shows the lack of reasons led to an omission in not examining granular detail of the evidence, which is why these fundamental contradictions have arisen between how the mother presented her evidence, how she presented her case in closing, and how these findings manifested themselves in the judgment. I think I've already addressed J, we would say this is actually fundamentally wrong because the mother herself accepted that her parents went to the operation and the father was there and did not raise any objection. And in respect of the finding at K that the father did not care about his son's health, this was a tenuous assertion on the basis that the mother claimed that the father had threatened to cancel the operation, but of course, again, we know that he went to the operation to support his son. And the mother actually said, at C14 of her statement, that she had found out that he could not cancel the operation. So it's difficult to understand the substance of this allegation and why it says that it constitutes abuse.
Was it rescheduled?
In the schedule, it's...
No, was the operation rescheduled? That's what the finding is in K.
No, it wasn't. It took place on the 4th of December, which would have been less than 2 weeks after the main incident of abuse on the 25th of November, where, in fact, the mother's complaint
This is a finding of threat, not of actual rescheduling.
Yes.
It's a threat.
Yes. But
Yes, thank you.
the father's case was that that did not, in fact, take place. His account, which the court may have read, was that he was very anxious that the operation should take place. The source of the argument was the grandparents' views about rescheduling the operation. There were therefore conflicting accounts from the parties about that, but that was not addressed within the judgment. May I just turn my back for a moment, please? Thank you. I'm grateful to Mr. Slater. The passage in the mother's oral evidence about the fractured fingers is at 192F.
192F.
Yes.
Thank you.
And in the same page, this also deals with her evidence in respect of finding A, as to whether she was hit in the stomach or not.
Which bundle? I'm in 192 is a blank page in my core bundle. Am I in the right place?
These were the updates.
Okay, not in her oral, in her updating. Okay.
I believe they were paper copies that were handed up to the court this morning.
Not well. I don't know.
Well, we're blessed with many different pieces of paper on our desk.
I think I seem to have got them.
I've got them in my bundle. Maybe my.
The difficulty is that for some reason the transcript and the transcribers didn't produce a transcript of the end of the mother's evidence, but a note of the evidence was agreed between the trial advocates. It's 15 pages running from 192A.
Okay, so we're 192F.
Yes.
This is dealing with the B. I think this was where you were referring to it.
Well, that
The fractured fingers.
yeah. So
where's it dealt with on this page?
it's at the bottom of the page where it says AG3B. The mother said he was. In fact, she makes a completely different allegation. She says the father was so angry he tried to hit me in the face, but instead hit the door and broke his finger.
And this is a note of the evidence, is it?
Yes.
It's not the transcript, but everybody's content that
Yes.
it's inadequate.
Yes, because there were such difficulties obtaining a transcript, and the evidence was actually circulated a few months ago, so everyone's had possession. In fact, this was a note produced by Mr. Powell's pupil on behalf of the Guardian.
Well
so
done, Mr. Powell.
it was accepted as being entirely neutral in those circumstances. And the Coercion just pointed out that mother's evidence does continue over the page at 192G.
That's the same as in her paragraph 23 of her statement. He was so angry he hit me, tried to hit me in the face, but instead hit the door
Yes.
and broke his finger. Different. You said there was a different account in the asylum interview.
Yes.
So this is the okay.
And
So that's then put to her.
yes, it is.
And this all refers to a finger in the singular, whereas elsewhere we find fingers plural, don't we, being broken.
Yes, and I think in fact, yes, that is correct. And just for completeness, on 192F, the contradictions about finding A were put to the mother at the bottom of the page, 3/4 of the way down.
Sorry, say that again.
The discrepancies in the mother's account in respect of finding A were put to the mother, 192F. It's the fourth of the paragraph down.
Sorry. Yes.
So, in conclusion, for those reasons, it's submitted that the findings at Schedule B in respect of emotional and physical abuse should be set aside, and we invite the court to remit the case to be heard by a judge of the Family Division other than Mrs. Justice Theis.
Is there any part of Mrs. Justice Theis that is preserved, or do you say the whole lot goes and you have to start
No,
again?
there's been no appeal or cross appeal against the remaining findings. We would say that they stand.
So it's only the emotional and physical
Yes,
abuse?
yes.
How many days would you need to do that?
If it was a composite hearing, we would submit that that would be a much shorter timescale in this trial, which I believe was listed for 5 days, that it could be accommodated. Well, it would have to be the scrutiny of case management decisions as to how this, if there was going to be a rehearing of these allegations, and how that would be managed, and if there was going to be oral evidence.
Can you remind me what's holding up the determination of the substantive application? Are there outstanding directions for any further evidence or anything? Just don't remember.
I've not been on, I'm afraid I've not been involved in those case management decisions, but it was originally listed for 2 days, I think last week, for final determination. That was,
And we've got the order of the 22nd of November, and it was going to be, the matter was going to be listed for a final hearing on the 20th and 21st of March.
yes, so that obviously had to be adjourned.
And all that was going to happen was that the parties were going to set out their plans for future care and contact. The father was going to set out his plans to secure safeguards, addressing matters set out in the reports of Mr. Edge, and the mother her plans. So that was the only additional evidence.
I believe there's, I understand from my instructions solicitors that there was some discussion about further questions being put to Ian Edge. He was instructed as a single joint expert. But I believe those statements have been filed or in the course of being filed by the parents.
But can I just recap then where we are? The final disposal or hearing was meant to be last week and had to be adjourned pending this appeal.
Yes,
So on your best case, you win this appeal,
yes,
you quash the findings on emotional and physical
Yes.
abuse, and those go back, you would say, for a rolled up hearing on
Yes.
those at the same time as the final
Yes.
disposal. So you've got 2 days for final disposal, but you need to add, what, a day or two to deal
Yes.
with this?
I would respectfully submit that 3 days would be ample to deal with.
When would
rolled
that
up
take
hearing.
place? When would that take place? From the
My
point of
lord,
view of listing?
currently the only listing is for directions on the 2nd of April for an hour before Mrs. Justice Theis.
But it would have to move away from Mrs.
Yes.
Justice Theis, so you'd need to find another
Yes,
High Court judge or deputy with 3 days
yes.
to deal with it.
Several
3 or
months?
4 days.
Well, my lord, one of the issues that's running in the background of this case, of course, is the mother's asylum appeal is listed
That's right. That's when
in
that's
July
July.
of this year. So, of course, delay is never ideal, but in the circumstances of this case, it may in fact align.
Yeah, that
If
might
an
align.
outcome-
So you'd be looking, say it takes a bit of time after that hearing for that decision to be handed down. Everybody will be much clearer.
Yes.
August, September time, won't they?
So I think it's been recognised in this case that the outcome of the asylum appeal may in fact be determinative of this application in any event.
Maybe, maybe not. There are a number of issues that arise in respect of that require consideration at some point. Right, anything else?
No, may I assist the court any further?
We're just going to take, as we started earlier, we're just going to take a break for a few, for sort of 5 or 10 minutes. So don't get far away, please.
Court rise the table. Just to make the court aware the live stream is still running.
Thank you.
Drive.
Ms. Guha, I think I probably misunderstood what you were saying about the consequences of the asylum application. Perhaps you were referring to the consequences if the appeal was dismissed?
Yes, I
Yeah,
was.
yeah. And then I think I would agree with you. Sorry for muttering away. Yes, Mr. Grayson.
Lords, my lady, just to address, before I start on substantive submissions, a few of the points that have arisen in the course of Miss Guhar's. In relation to outcome, if you do allow the appeal in relation to the findings, for our part, we see and submit that there would be some considerable difficulty if the consequence of that was remittal only of the findings that have been challenged on this appeal, rather than the entirety of the factual background. Well, I rather.
So what do you say? What's your
Yes.
analysis?
Well-
What's your...
My lady, if you find that the judge has not dealt properly with these, in our submission, the only possible outcome is remittal of the case to another judge
Start all
for
over again?
potentially.
Well, partly because one of the criticisms is silo.
Yes,
And so you need to hear all the evidence about everything in order for the new judge to have the overall perspective.
well, my lord, that's precisely the point. And we imagined amongst ourselves outside a situation where a judge hears a particular piece of evidence in the context of a remitted hearing that is relevant to one of the other findings, and it's suggested, well, you can't really consider that because Mrs. Justice Theis concluded this in relation to that aspect of the case, and that prevents them then from considering that evidence, or well,
Yes,
it wouldn't actually prevent them, but could be said to prevent them
yes.
from considering that in relation to the findings that are being challenged here. So the unfortunate consequence from the perspective of reaching a welfare outcome for this child would be a remittal of the case as a whole. The judge who then heard that remitted case may be asked to take certain case management decisions. It may be that there's a suggestion that there need not be a fact-finding, although in our submission it would be difficult to proceed with this case without there being one, or at least a fact-finding element. It might be said that the allegations should be pared down in some way, although again, on behalf of the mother, we would see that as being a difficult proposition. But certainly there needs to be an open field for that judge to consider this case.
What,
again.
and then you would seek to resurrect the allegations rejected by the judge?
Well, my lord, yes, because it would be part of the evidence as a whole.
Yes.
And if the judge rejected those, then on the basis of the analysis that is being offered before you today, of course, that would have to be brought into consideration of the others. And if the judge didn't do that, then the silo point is firmly engaged. So, my lords, my lady, we say that is the consequence. And that may lead to a further exercise of the type that was undertaken in this case, of a split hearing where there's a fact-finding and then a welfare analysis later, or, at the very least, it is likely to lead to a hearing that is longer than the 3 days that was discussed before the short break, bearing in mind that I think this hearing took 4 and an extra
It
day.
says on the transcripts took 3, 11th to 13th, 11th.
But we resumed for a further hearing on, I think, the 22nd of November for judgment and the consequences of that.
Okay, so you had a separate handout, so another 4
Yes.
days, and you're talking about directions hearings as well, so it's tying
Well,
up
they
the
would
court for the
certainly-
best part of another 5 days.
Yes, there would certainly have to be a directions hearing. In terms of the question that was asked of Miss Guhar as to whether there were any further directions required going into the welfare hearing that was envisaged, the only thing that I think we think was left up in the air was whether a further report from the Guardian was required.
Oh, right, yes.
One wasn't directed previously.
Yes.
I think there had been some considerable slippage in the timetable and the pre-trial review that took place, I can't remember off the top of my head the dates, but relatively recently, was due to be earlier. But a point had been raised as to whether Miss Demery should offer any further analysis in the light of the findings that had then been made, because as you may have seen, her initial report was offered on a contingent basis, offering different recommendations as to whether certain types of findings, as she put it, the most serious ones, were made. So there would be an opportunity, if you upheld the decision, for Miss Demery to offer a more certain analysis on the basis of set findings, or it may be necessary, if you overturn the findings, for that to be done at some later stage, if there is a fact-finding hearing as a separate exercise and then a welfare hearing later. Of course, probably before any of that will be the mother's asylum appeal. Of course, what I don't know and don't want to offer any guesses at is whether it's likely that a judgment on that will appear swiftly or not. So the appeal will take place in July, but I don't know when we can reasonably expect to have an outcome of that.
The guidance deals with Hague applications and asylum claims that are
Yes.
linked. Is that being applied in respect of non-Hague applications and asylum? Because if so, it should be expedited. The asylum process should be being expedited.
That guidance has been raised and I think really adopted in this case, albeit
Right,
there are
okay.
distinctions between the two categories. It might or might not be surprising to hear that the listing on the 2nd of July follows an application made by the Secretary of State for expedition of the appeal process.
Right, okay.
And these points were all canvassed before Mrs. Justice Theis, I think even before the November final hearing, and requests were made for expedition,
Yes.
and expedition has been sought, and the 2nd of July is the date that we have received, which has led, I hope not unfairly, to some pondering as to whether we in the family division might have a different idea of what expedition means than applies.
Well, it depends what happens
In
in
other
this
contexts.
case, doesn't it? I mean, this is hardly expeditious how this case
No.
has been addressed.
I didn't mean specifically in the
Yeah.
context of this case. I meant generally. I mean, it might be thought that a request for expedition made in October leading to an appeal hearing in July is not particularly expeditious, is only the point that I was
Yeah, very well.
really driving at.
So the judge rejected all the more serious allegations made by the mother.
Well, I don't particularly like to categorise them as more or less serious, if my lord doesn't mind. But
No,
yes,
I don't mind.
a number of the allegations that were
Yes.
made were rejected. Can I deal specifically?
And what impact do you say the findings that have been made by the judge? What is their relevance? What is their significance to the overall determination of the application the child be returned to Egypt?
Well, as a broad brush starting point, it means that the mother and child are victims of domestic abuse and have a level of vulnerability as a consequence of the experience that they've received. This being an exercise of determining the child's paramount welfare needs, that has to be factored into the question of return, both in relation to the impact upon the child's mother of returning to an environment where she experienced physical and emotional abuse at the hands of the father, and the impact on the child of being returned to that environment, who on the judge's findings was exposed to the father's physical and emotional abuse of the child. In terms of an aspect of the summary return process, it also has a direct impact on what sort of measures of protection, to adopt a broad term in relation to them, the court might want to see before there is the prospect of a return.
Right.
The judge in this case was, we would say entirely correctly, very focused upon the risk of the child being separated from the mother. Not least because, of course, as a consequence of the period of time that the mother and child had spent in England, the child's lived experiences being in the care of the mother, but also because of the findings about the father's behaviour that have been made. So when the judge, on adjourning the case at the end of the fact-finding, sought further details about protective measures, that was one of the things that she was particularly focused upon in the light of the expert evidence that the court had received from Ian Edge. So, my lord, it is directly relevant in those two ways. But of course, when conducting a paramount welfare inquiry, the court will have to, whether through the lens of the welfare checklist or generally, look at all of the aspects of the child's life and the impact upon him of being returned. And there may be, of course, when conducting a holistic exercise in that regard, factors that point in favour of a return, and Ms. Guhar understandably focused on some of those, but also bearing in mind the time that the child has spent in this jurisdiction, any stability he's encountered here, although of course, as you will have seen from the papers, there's an issue about that in light of the mother's experiences and the accommodation particularly, and financial support, if it can be so called, that she's had access to since claiming asylum, but also the impact upon him and the mother together of returning to this environment are all relevant. So in our submission, the findings sought, the mother's allegations against the father, the findings upon them are directly relevant in lots of ways to the question of return, not least because the court has to conduct a global holistic analysis of the child's welfare, but also specifically in relation to protective measures.
Thank you.
Well, I wanted to address the somewhat vexed question of the finding about the mother being pulled by the hair. That, as has been pointed out, does not appear within the schedule. And of course, when the judge makes the findings about the incidents in November, what the judge actually finds is that the mother has proved her allegations as per the schedule. So we have been trying to work out, in the light of that, exactly where it came from. And it seems to have crept in during the process of drafting of the order. My Lord Justice Moylan will know we are required now to set out in the form of a schedule findings that are made on an order per PD 12J, and the drafting of orders falls to council. We can't work out exactly where that came from, so it's probably safest that I take the blame for that being included within the draft. And that draft was then approved by the judge, and what we have not been able to remember is whether there was any dispute in relation to that aspect of the findings set out in Schedule B of the order when the judge was asked to approve it. But the judge approved it in that form. So, my lord, my lady, we accept that that finding was not made and that the mother's evidence was, as per her statement where she corrected the earlier statement, the mother said that didn't happen. But that is not an error of the judge in her reasoning and appraisal as set out within the judgment. It's an error.
Just a slip in the order.
Yes.
So that was something that could sensibly be tidied up with the judge
Yes.
immediately after the hearing.
Indeed.
If anybody had spotted it.
Yes.
What do you invite us to do about that now? Whatever we decide on the other bits, you just say we can safely just take that out. It shouldn't be there.
Yes, because the mother said in her written evidence and in her oral evidence, as you've been taken to, that didn't happen. My overriding point in relation to this, then, is that it isn't a failure of the judge's analysis or to weigh the different accounts. On her judgment, she didn't, in fact, make that finding. No, it's an error that has crept in subsequently that is the fault probably primarily of me, but collectively of the advocates.
So it's the whole of E.
Forgive me, my lord. I think that's right, but I just want to have it before me before I...
Is the whole of ego, or is it just the dragging by the hair bit?
Well, it is just the dragging by the hair.
Well, except that if you, I thought you were saying the judge didn't make a finding in respect of it, because all she said was, I find the matter set out in the schedule at 3 and 4, and makes no finding in respect of what happened later on the 24th at all. Is that not wrong?
Within the judgment, that is right.
So she didn't make a finding?
No. Had she have done, the mother's evidence in relation to being slapped and hit was there, and she made that.
I understand that, but
in terms of the judgment, my lord is right.
So you would have to accept that E can't stand because it wasn't a finding made by the judge.
Yes, her findings were limited to 3 and 4 in the schedule.
And the schedule didn't include an E thing?
No.
Okay.
Having addressed that, I just wanted to, because I think it comes in relation to the same aspect of this case, make reference to the process by which the mother's evidence was gathered and the criticisms in relation to that. And the mother gives an explanation in relation to this in the statement where she makes the amendments to her earlier evidence, which is in the supplementary bundle at C171, electronic page 253.
Yes.
So the mother sets out there how her first statement was taken following meetings that she had with her previous solicitors. Milady, it's no answer to that to say, well, these were experienced panel solicitors. That was the mother's experience of how her instructions and evidence was taken. And it's significant in our submission within that she was giving instructions in Arabic and then translations were being made by her brother-in-law, which of course is no part of a proper and accurate process when evidence is being put before the court. That is likely to be accurate as a description is supported by the fact that at the end of the mother's first statement, there is no statement from an interpreter setting out that it was properly, truly and faithfully interpreted to her. I won't take up any significant time in dealing with what the knock-on effect of that was, but it did have an impact on the preparation also of the schedules of allegations. And there was, I think, one point where there were several different versions of schedules before the court. Mrs. Justice Theis required that to be resolved, and that is why we ended up, and I would just ask you to turn to A19 in the same bundle, which is electronic page 24. But we ended up with a situation where the composite schedule of allegations, which was the schedule that was used for the final hearing, was sworn by the mother to be true on the 24th of April, only then in fact interpreted to her on the 26th of April, and then interpreted to her again on the 6th of November. And that was because in preparation for that document it was amended and amalgamated with other versions, so it had to be translated to her again. Now, I accept, of course, that to an extent only goes so far, but that is some of the background and not the complete background to what Mrs. Justice Theis says in her judgment in the core bundle at page 17, paragraph 75. Because just as a straightforward explanation, if one has a statement that is then corrected, but the corrections refers back to an earlier document, it gives rise at the least to the possibility of confusion, and the allegation stroke supposed finding about dragging by the hair is an example of one of the confusions that this caused. But it also, of course, placed the mother in a difficult position because she was repeatedly met with the assertion that she had given inconsistent accounts, notwithstanding, of course, that she had sought to explain why one of those accounts, the first statement, which she had later corrected, came to be in the form that it was. And then the judge goes on to consider in paragraph 76 on the same page some of the other issues that may have arisen in terms of the parties, both of them, giving their evidence, which, as we inevitably point out, they did at length over a number of days.
Yes.
My lords, my lady, those points having been made, I wanted, unless there was any other particular thing that fits into that broad category that you would want to raise now, to touch on the principles that apply to appeals of fact-finding decisions.
Very briefly.
Yes, and it will be very brief,
Yeah.
really by reference to our skeleton argument, which is within the core bundle in this regard at paragraph 72, beginning at paragraph 23.
Yes.
We've touched within those paragraphs on three very well-known cases, Theis UK Limited, Volpe and Volpe, and the specific family case of Rief. They are in the authorities bundle. I don't think it's necessary really to go to them unless you would be helped by my doing so.
No, thank you.
Well, the summary of the relevant principles in Volpe that we've set out at paragraph 26 may be of particular importance in this case, and particularly subparagraph 3, which we've quoted on page, electronic page 7, well, and bundle page 74. An appeal court is bound, unless there's compelling reason to the contrary, to assume that the trial judge has taken the whole of the evidence into their consideration. The mere fact that a judge does not mention a specific piece of evidence does not mean they've overlooked it. And 6, in relation to the lack of reasons for a judgment will always be capable of having been better expressed, and an appeal court should not subject it to a narrow textual analysis. But it might be thought to be obvious that where a court hears and receives so much oral and written evidence, it will be possible to point to aspects that it said have not been specifically recounted within the judgment, and to say, well, this should have led to this, that, or other conclusion. And in our submission, a great deal of the father's challenge to Mrs. Justice Theis's findings here amounts to an exercise of that nature, without, and this is something I will come on to shortly, necessarily addressing the fundamental basis upon which Mrs. Justice Theis reached her decision, which was the differing accounts of what we describe as the key precipitating event on the 24th of November, and what that meant for the father's credibility and tendency to act in a physically and emotionally abusive way towards the mother. In relation to Rief, which we quote from at page 74, paragraph 27, and this is a straightforward and well-traversed principle, but of course it's necessary to look at Mrs. Justice Theis's judgment as a whole, because she does engage in an exercise of traversing what she considered to be the important aspects of the evidence, and she then weighs those up and reaches conclusions in relation to them. As that quote continues, the judge need not slavishly restate either the facts, the arguments, or the law. And the memorable quote that there's no need for the judge to incant mechanically passages from authorities, evidence, or submissions as if a pilot going through a pre-flight check. I'm not going to suggest that it's something that needs to be turned up in this context, but if you read at some later stage the closing written submissions filed on behalf of the father, they make really all of the points that are raised today as to the challenges on the evidence, the mother's accounts. So the judge had all of that. The father's case was set out in full, both in the challenges to the mother in her oral evidence and also in the written closing submissions that were filed. So the judge knew what the fundamental tenets of the father's case were, made reference in the judgment in a way certainly we would submit is sufficient to make it clear what evidence she considered most important in reaching the conclusions that she did, and then reach the findings that she did. Lastly, in this regard, straying in within our skeleton argument to a response to the grounds, we've made reference at electronic and bundle page 75, paragraph 29, to the fact that though a request for clarification was made, it was limited to one particular aspect of the father's case. Within the request for clarification, the father sought to restate, as he did through the closing written submissions, a request that the judge make findings against the mother in relation to her credibility and that those be set out. And the judge responded to that request, but did not make any request for further or better reasons in relation to any aspect of the findings made against the father or clarification of them. And that might have been important in this context. We don't accept, and we'd invite the court not to accept, the proposition that the judge's judgment was so wanting that it was not possible to deal with it in that way. I mean, there are lots of aspects, it might be thought, of the challenges that the father now seeks to bring that could have been raised with her but were not.
Is there perhaps anything in the point that, since the judge had to be actually reminded, or indeed specifically asked, to include in the order or in the findings adverse to the mother, she may perhaps not have regarded them in their totality, in the way which does form quite an important part of the case that's now being advanced on this appeal.
Well, my lord, if you turn to within the core bundle, page 325, there is there the judge's response to the request for clarification. Sorry, I'm probably starting at a really unhelpful place, and it might be better to go a couple of pages earlier and look at what the request actually entailed. So 323
Yes,
is the starting point. So there is at 323 the particular points of clarification that were sought. And then the judge responds at 325 by pointing to the paragraphs in the judgment where she's made those findings or
Yes,
reached those conclusions.
Thank you.
So, my lord, we would say it's not a fair criticism to suggest that she had to be pointed to those and prodded to make them. In fact, what she's saying is, well, I have made them.
Yeah, I mean, plus the fact in a complicated case like this, one always has to assume that unless there's very strong evidence pointing to in the opposite direction, that the judge has done her job.
Yes.
And has to be credited with realizing that she needs to stand back and look at the picture as a whole as well as in a granular fashion.
Yes, my lord, indeed. But this is a specific example, we would suggest, of her pointing out that she has done that.
Thank you.
And they were then included in the recitals to the order as a consequence. Of course, one might think that if this exercise was going to be done in relation to what might be described as the positive aspects of the father's case, why couldn't it have been done in relation to the ones that he says now weren't dealt with properly? And the judge might then have been able to give a response, or at least explain why there wasn't to be one. And just, again, I'm not going to take up time by going to it because the principles are well established, but we've made reference within the skeleton to Rio at the point that I've taken you to. The full relevant passage is within the authorities bundle at tab 3, page 64.
And you don't want us to go there, you're just saying that's where it is.
Yes, because the full passage is of some relevance and you may wish to consider it in due course.
Thank you.
Can I invite you to turn then to the judgment at page 3 in the core bundle?
Yes.
And to begin, if we may, in this particular regard, at page 9.
When you say in this regard, in what regard?
Well, what I'm going to come on to, forgive me, I should have introduced that, is to look at what the judge specifically recounts within the judgment and how she then deals with her analysis of the evidence in that regard. And, my Lord, I've invited us to start at page 9 because that's where the judge begins to set out, rather than a narrative history of the case, the factual issues as she identifies them.
Thank you.
It would have been more helpful to begin in that way, perhaps.
Yes.
So, Lord, specifically, and in our submission, she addresses things in this way because of the focus within the evidence, but also in the light of the findings that she made within her conclusions upon the incidents in October and November 2021. She starts at paragraph 44 by setting out the mother's case in relation to the October 2021 incident. And specifically her allegation that that involved violence towards her and the child. And well, to introduce where I'm going, and this is a point that was raised in discussion with Ms. Guhar also, what this demonstrates in our submission is the exercise that Mrs. Justice Theis undertook of differentiating some aspects of the evidence from others in terms of the findings that she reached. She reached the conclusion in the end that the father had demonstrated physical and emotional abuse towards the mother, but rejected the mother's case as to violence towards the child. So this isn't a situation where either on the one hand, having found the mother to have been truthful about some of the allegations, she accepted everything that the mother had said, or on the other hand, and there is, we would submit, a flavour of the father's case to this, that having found the mother wanting in some aspects of her credibility, she could not accept anything that the mother had said, either of which approach would have been wrong. But this demonstrates, as does, of course, her approach to the findings as a whole, that the judge was able to filter out different parts of the case, find some and not make findings in relation to others. As one would expect in a case of this nature, the judge was directed within the course of the authorities that were provided to her to lots of principles about fact-finding hearings, but she was also within that directed to and said through a quote from a decision of Mrs. Justice Knowles in a case called Re P, incorporated to be read into her judgment a Lucas direction. So she did set within her analysis of the law, which appears later in the judgment the ground for approaching things in that way, insofar as that may be relevant. The next significant paragraph in relation to the findings that the judge made is paragraph 46, where the judge sets out there in relative detail what the mother had said had happened in the course of the argument on the 24th of November. Just as a precursor to this, it was suggested on behalf of the father that the judge had not resolved the issue of whether Jason was there or not.
Sorry, A.
I'm sorry, my lord. Yes. Forgive me.
Yes.
Had not resolved the issue of whether the child was there or not. We don't accept that that's correct, because the judge does, within her findings, conclude that these events happened in his presence. But in any event, here the judge sets out what the mother had said happened, her description of the mother and father attending before a priest to try to assist in resolving their argument, the later events on the 24th, and you will see there that the judge recited the mother's earlier evidence that involves dragging by the hair, which may, although this is speculative, have been where that crept in, but I don't know. And the consequences at the end of that paragraph, insofar as what happened with the mother and father's relationship, that being that the mother after this left the family home with the child, never returned, went to the police station and made a report. As we've pointed out in our skeleton argument, whilst it's suggested now that the judge was required to resolve whether that report was real or a forgery, it was never put to the mother that that was a forged document. So the judge was entitled, if through reciting it in this way, that's what she did, to take that as corroboration that something happened that was serious on the 24th of November. But of course, the other and perhaps most serious consequence was that this was the end of the mother and father's relationship. It never resumed. The mother never went back to live in the family home. The child never did. And the child's contact with the father thereafter was limited to the father seeing the child at nursery on some occasions. In fact, the judge found it difficult. And if you read through all of the transcripts, you might also find it difficult to come up with any hard and fast answer as to how frequently that was occurring. But certainly, something happened on that occasion that fundamentally changed the dynamic of this family. The father's account, as set out in his written submissions, then appears at paragraph 47. There are, as can be seen from that paragraph when set against the recital of the mother's case, considerable differences between them on the written evidence. I mean, one particular striking example was that the father in writing denied that there had been any meeting with the priest. There was also the issue in relation to whether the child was there or not. There was the father's lack of any recognition that he had a difficult relationship with the mother's parents, or either of them. And the judge has set out there his written statement saying, "I treated her parents as if they were my own mother and father." The judge goes on then at paragraph 48 to set out the circumstances of the operation on the 4th of December and the communications between the parties between that, and then what transpired in later months. Specifically in that regard, as to what happened following this incident, and particularly in preparation for the mother's departure, there is paragraph 51, where the judge deals with the mother's case about the father's state of knowledge about her departure from Egypt with the child and the steps in preparation for that. It can't reasonably be said in our submission that the judge was somehow blind to what she had considered this mother to have done in preparation for leaving and through leaving Egypt with the child in the way that she did. The same point arises in relation to paragraph 52, which specifically addresses what is described there as the purported Egyptian custody order and the difficulties with the mother's evidence about her knowledge about that and what she sought to do with it. So, my lords, my lady, there were in those two aspects, which of course formed, as Miss Guhar, I'm paraphrasing, but sought to describe them, key planks of the father's case, expressed recognition in the judgment of what the mother had said and the judge's disbelief of it. Reading the judgment as a whole, it's quite apparent that the judge had identified and knew about the credibility issues that arise as a consequence of those aspects of the case, albeit it might be thought that the forged order holds greater significance in terms of credibility than steps a parent takes in a case about abduction to prepare their abduction of the child. On page 16 of the judgment, the judge goes on to consider the submissions that have been made to her on behalf of each party. At paragraph 71, the submissions made on behalf of the father are summarised, including reference to many inconsistencies in the mother's account, significant delay in raising detailed issues about domestic abuse, the lack of evidence that was said to show that she was at risk of harm from the father in the period from when she left the family home to when she and the child departed from Egypt, the ongoing communication about the child, specific reference to this because it actually mirrors the language used by Miss Guhar when she made this submission to you, but towards the bottom of the page on 16, the context of timing when the mother makes her detailed allegations they submit is important. Only after the father has issued proceedings here. And my lady, the judge made specific reference to all of these aspects that it's now said she didn't take either into account at all or sufficiently into account when reaching conclusions about the credibility of the mother. There is some helpful analysis on the following page 17 at paragraph 73 offered on behalf of the guardian. A submission made on the guardian's behalf that both parents were evasive, deflecting in their answers. It was identified that there had been inconsistencies on the part of the mother regarding allegations of abuse. And at the bottom of the paragraph, as regards the father, minimisation by him in respect of his admitted behaviour. And that is perhaps particularly significant because it was the father's minimisation or differences in his account as between his written evidence in relation to the 24th of November and his oral evidence that the judge considered to be so important when making findings that the father had acted broadly as the mother alleged he had on the 24th of November, and as justification for the wider findings of physical and emotional abuse that the judge made, that her conclusion about the 24th of November supported the proposition that the father had a tendency to lose his temper during arguments and to be physically and emotionally abusive when he did so. I'm going to come on next to the discussion and decision section of the judgment, and that might therefore be an appropriate time to stop.
As you know, during the course of her submissions, Ms. Guhart took us through her criticisms of each of the findings in the schedule.
Yes.
And I think it would be helpful if you did the same
Yeah.
to seek to meet the points that she raised in respect of them.
So,
So we'll start again at 2 o'clock.
Court by disabled.